Ability of evidence has been limited by three facts. The first is that the case was very thoroughly investigated between 2000 and 2006. Secondly, there is a large mass of documentary evidential material. Those documents have been preserved and copies have been handed to the accused. And the third is most of the people who testified in the Sheikh trial are available to testify for the state. There are four exceptions. They include Ms. De Leek and Mr. van der Walt. The other two are a Mr. Yusuf Surti, who as far as the state knows died in December 2018, and Mr. Gavin Woods, who died on the 15th of January 2024. The third issue relevant to the merits of Thales's application is that it doesn't allege that the conduct of the state in this case has led to the disappearance or destruction of any documents instrumental to its defense while they were in the custody of the state. The fourth concerns the evidence against Thales, to which I've just referred. This court will obviously know what the Sheikh trial court made of the evidence of the people on the state's list of witnesses. But I do need to add something in connection with Ms. De Leek and Mr. van der Walt, because they have passed, and because their passing has been specifically raised by Thales in support of its application. It's the second string to its bow. In its answer, the state has said that as regards Ms. De Leek, at the trial, it intends applying in terms of a number of alternative statutory and common law rules for the admission of the transcript of her evidence given at the Sheikh trial on page 36 of the state's heads in the Thales application. Now, Thales has indicated in its replying affidavit at paragraph 57, record page 663, that it intends to oppose the state's application for the admission of that hearsay evidence in the criminal matter.
Just a moment, please.
And in our respectful submission,
So just a moment, please, Mr.
I
President.
apologize.
Yes, Mr. President.
In our respectful submission, that is a dispute for another day. It's a dispute which will arise for determination when the state makes the application for the admission of that hearsay evidence. And as authority for that proposition, we respectfully refer you to the following remark by the Constitutional Court in the case of Savoy. That case is number 17 in our bundle, and paragraph 49 as well as footnote 74 are relevant. Paragraph 49 in particular, it's at the one at page 374. And there the court said, needless to say, it would be ill-advised to attempt to anticipate instances where the admission of hearsay would be so unfair as to infringe an accused's right to a fair trial. That is something best left to the trial court. And although you are the assigned trial judge in this matter, at the moment the adducing of evidence hasn't started, and references to a trial court in judgments like that are apposite with respect. As regards Mr. van der Walt, the state has indicated that, and this is again in its answering affidavit, this time at para 135, record 118, that at the trial it intends calling the co-author of the FTI forensic report, Ms. Helena Potgieter. And we point out that the state could have called either of them while Mr. van der Walt was still alive. And the fact that the state is now limited to Ms. Potgieter doesn't give rise to an infringement of section 35(3)(I). By contrast, we have no doubt that the accused will raise an infringement of section 35(3)(I) in opposition to any application by the state to have the hearsay evidence, in other words, the transcript of Mr. Leake's testimony and the encrypted facts admitted in evidence. And they're quite entitled to do that. Indeed, it is the obvious, with respect, basis upon which such an application would be opposed. Now, all that we wish to add in that connection is that the state accepts that the trial court has to rule on the application for the admission of that hearsay evidence and any other which the state may seek to adduce at the latest before the state closes its case. That was held by the SCA in the well-known Ndlovu case. That's number 16 in the state's bundle at paragraph 18, page 369. And that was quoted with approval by the Constitutional Court in the case of Molimi, M-O-L-I-M-I, at para 36. That's in the state's bundle number 15 at pages 346 to 347. But what we would do is just make the following point, my lord. All of this related to things which are down the track if this case is permitted to continue. And it's this. If, as things turn out at the trial, the hearsay evidence to which I've just referred is duly admitted, then contrary to what Mr. Zuma has submitted in his replying affidavit, paragraphs 34 to 35, that's at record 925 to 926, that outcome, in other words, the admission of the hearsay evidence after hearing argument from both sides and considering all of the factors listed in section 33 C of the Act 45 of 1988, if that is the basis on which it's admitted, that outcome will not constitute an unjustified infringement of the right to challenge evidence in section 35(3)(I) of the Constitution. And that is stated by the Constitutional Court in the case of Kapa, K-A-P-A, at paragraph 101. It's in the state's bundle number 7, and the relevant paragraphs at page 107. And again, that was approving Ndlovu in the SCA, this time paragraph 24, which is at page 360 of the state's bundle. So much for the manner in which the state intends dealing with the deaths of these two individuals, Mr. Leek and Mr. van der Walt. That brings me to the elephant in the room, the deaths of Messrs. Tetard and Moineau, which I think it's fair to say is the mainstay of Thales's, or the mainstays of Thales's application. And Thales's contention is really quite far-reaching. My learned friend, Mr. Roux, contended that following their deaths, Thales was paralyzed from the neck down, I heard him understand. In other words, it couldn't move its arms and legs to defend itself. And the sense that he was conveying is that it can't challenge any of the state's allegations, and it cannot call any witnesses to defend himself. That is the case that has been laid before you for decision. And that requires a somewhat closer examination of the situation in connection with Mr. Tetard, Mr. Moineau, and then whether there aren't any other witnesses from whom Thales can take instructions and or call should they go on their defense. So starting with Mr. Tetard, what is conspicuous by its absence is any answer by Thales to the point taken by the state in its answer in the present matter, that in the 2018 permanent stay, Thales alleged that Mr. Tettard was not prepared to assist Thales in any way. He wasn't prepared to return to South Africa, and he wasn't prepared to testify in South Africa or any other forum should a trial take place. And you will see that mentioned in paragraph 136.1 of the state's answer in the Thales application at page 119. And it is in the referenced paragraph, the state refers to the fact that in that 2018 application, Thales put up an affidavit by Mr. Tettard, which is dated the 11th of March 2009. A copy is Annex AA10 to the state's answer at pages 576 to 594, in which he said, amongst other things, he wasn't prepared to testify, and I quote, in any forum under any circumstances should a trial in this matter take place, unquote. And that one sees at paragraph 49 of that affidavit by Mr. Tettard at page 592. So that was the case which Thales took to the full court as to say why they were now in a bind, because Mr. Tettard, the central figure, was not available to them. He, of course, is overseas at that stage. In its founding affidavit, Thales doesn't explain when and why Mr. Tettard's attitude, this is now on Thales' version, changed in the period between November 2018 and his death on the 5th